Good morning. My name is Arnaud Folliard-Monguiral. I'm working with the Boards of Appeal in the litigation service, and we will spend the next hour addressing the different facets of the notion of bad faith. The purpose of this presentation is twofold. First, we want to understand why there are so many facets in the notion of bad faith. One reason is that bad faith is an absolute ground for invalidity. But we also know that it is very often invoked by third parties who claim to have a sanction against the misappropriation of rights that they have, but which might not be protected in the European Union. A second aspect of bad faith, and a certain difficulty in interpreting it, is that we know, and the law says it, that bad faith must be established on the date of filing of the contested trademark. However, circumstances arising before or after the filing in the Union or outside the Union may also be relevant. A third aspect, which may lead to uncertainties, concerns the extent of the annulment once bad faith has been established. We will try to cover all these aspects, trying to draw some patterns establishing or militating in favor of a finding of bad faith during 50 minutes, and afterwards there will be a 10-minute session of questions and answers. You have a caption at the bottom of the page you are using for the streaming, in which you can type your questions at any time, and I will try to give an answer, if I can, at the end of this presentation. The law says very little about bad faith. It refers to bad faith as the notion without making it more explicit, except by specifying that bad faith must be established when the applicant filed the trademark. You will have a number of clarifications regarding the office's practice in our guidelines, which you see at the bottom of this page. Regarding the general principles, we are lucky because the case law has clarified a number of aspects relating to bad faith in a number of judgments, including in the leading case Skykick, in which the Court of Justice in 2020 said that bad faith presupposes a dishonest state of mind or intention. That does not say much, except that bad faith is subjective misconduct. But not only that. The Court of Justice specifies that there are at least two relevant aspects to bad faith. One is when a trademark applicant files for the trademark without engaging fairly in competition, but rather with the intention of undermining a third-party interests. This is important because this gives a definition of bad faith in terms of misappropriation of a third party's right, which does not belong to the trademark applicant. But bad faith is not only that. The Court of Justice goes on to specify that apart from the misappropriation of third parties' rights, there can also be bad faith when the trademark applicant files the trademark not for engaging into a fair competition, but in order to misuse the trademark registration system for purposes which are not that of the trademark law, that is, making sure that all marks that are filed are meant to be genuinely used. So you have these two aspects again, misappropriation of third parties' rights and misuse or abuse of the law for purposes other than using the trademark in the future. Among the general principles, the Court of Justice specified that bad faith is an autonomous concept of EU law, which means that it must be interpreted in the same way across the European Union. Good faith is presumed until proof to the contrary is adduced by the cancellation applicant. And the relevant point in time for determining whether or not there is bad faith is the date of filing of the trademark application or the trademark that has been registered afterwards, knowing, and that we will see in a minute, that circumstances prior or subsequent to the filing may also be relevant, to the extent that they allow shading a different light on the intention of the applicant on the date of the filing. The relevant circumstances when examining bad faith are neither limited in time, again, circumstances before or after the filing may be relevant, and they are not limited in space either. In Untitled, the General Court relied on a number of circumstances arising in Mexico in order to establish that the trademark applicant was deliberately trying to misappropriate the rights on a trademark which belonged to a US operator by filing a similar mark for dissimilar goods and services within the European Union. The goods that were applied for were in particular watches, when Untitled, the US mark, was protected in respect of clothing articles. And the General Court relied in particular on the circumstance that this misappropriation strategy had already been carried out by the trademark applicant in Mexico. The Court of Justice went on to say that likelihood of confusion is a relevant factor, but it is not decisive, it's not even totally required. And as a consequence, the dissimilarity of the goods and services, as in the Untitled example, is no bar to a finding of bad faith. We will come back on this issue in a minute. Now that we have seen those general principles, we will see what are the factors that are likely to indicate bad faith and those of the factors which, on the contrary, would militate against such a finding. The Court of Justice gave us a list, or an indicative list of factors. This list is non-exhaustive, and the point I wanted to make at this stage is that the list of these factors has been nuanced by the subsequent case law to the extent that the factors relied on or made explicit by the Court of Justice in the Lindt case were certainly specific to the facts of the case. If you remember the Lindt case, a three-dimensional trademark was applied for by Lindt Gold Haze for the shape of a chocolate rabbit, and it was established that a number of operators were already using similar shapes in Germany and in Austria for selling chocolates. In this context, where you had something that could indicate an anti-competitive conduct on the part of Lindt Gold Haze, that is, in order to obtain a blocking position which would evince competitors from the chocolate market using similar shapes of animals, the Court of Justice gave us a number of indications or a number of parameters which are relevant when examining bad faith. One is the identity or the similarity of the signs being the mark that is contested, which is allegedly filed in bad faith, and the signs that are used by other competitors. Another relevant factor is the knowledge by the trademark applicant of the use which is made by other parties of identical or similar signs. We will see how this knowledge can be established in a minute. Knowledge can be a matter of presumption, we will see. It can be presumed, but in itself, it is not sufficient in order to establish bad faith. On top of this knowledge of the use made by third parties, you need to establish a dishonest intention. And this dishonest intention must be determined by reference to objective circumstances of each case. So again, the difficulty in applying this notion of bad faith is that you try to read what was on the mind of the trademark applicant on the date of filing, but by reference to objective facts. One of the characteristics or one of the facets of this dishonest intention would be the willingness to apply for the mark not for using it, but rather in order to obtain a blocking position which would prevent a third party or third parties in general from entering the European Union market for a given product. We see in this statement made by the Court of Justice that again we mix two things, an intention to block third parties and competitors from entering the market and the lack of any intention to use the mark on its own. We will see in Skykick, the leading court of the Court of Justice, that the filing of a trademark without an intention to use this mark is as such an indication of bad faith, irrespective of any intention to block the European market or to block third parties from entering the European market. Of course, if you file a trademark without any intention to use it, a consequence is that it has anti-competitive consequences and that it prohibits other competitors from using similar signs in Europe, which runs against the objective of the trademark law. When assessing bad faith, you need to have regard to the degree of legal protection enjoyed by the third party's signs and the long-standing use of the sign which is made by a third party. Again, if you try to monopolize or to obtain an exclusive right to the detriment of third parties when those third parties have already been using a similar sign, that may be indicative of an anti-competitive misconduct. The nature of the sign may also be relevant, the Court of Justice finding that it is more likely to obtain an unfair competitive position on a given market if you obtain the right for a three-dimensional trademark, which consists of the shape of a given product, such as the rabbit shape for chocolates. Ultimately, the extent of the reputation that the mark or the extent of the reputation of the mark which the applicant files may be a factor which militates against bad faith if that may lead to the conclusion that the applicant was in fact striving to consolidate its competitive position. And lastly, but very important, all those factors, which are again not an exhaustive list, all those factors must be assessed altogether in order to come to an overall conclusion on whether bad faith is established. If we review all those factors, and if we begin with the identity or the similarity of the signs, we see that the case law is very clear that the near identity of signs is a strong indicator of bad faith. In the doggies case, the General Court found that the near identity of the signs could not be fortuitous. It could not be a matter of coincidence. And on this account, we could also already draw a conclusion on what was the intention of the European trademark applicant, which was to misappropriate the reputation acquired by the doggies mark outside the European Union. A similar reasoning can be found in the Stilo and Cotton case, where the Court of Justice confirmed that the similarity of the signs and the lack of coincidence in those similarities was a relevant factor. Knowledge of the use which is made by third parties. The European trademark proprietor must know or must have known about the use which is made or which was made by third parties. So how can you establish this knowledge? The Court of Justice and the General Court elaborated a bit on this by saying that this knowledge could be assumed or could be presumed in a number of situations, including where the parties were bound by contractual relationships, even if this is only pre-contractual relationships. We will see that in a minute. When the sign which is used, which was previously used by a third party, had acquired a reputation, or where this sign, without having a reputation, was used over a long period of time and over a certain extent, which makes it most improbable that the later trademark proprietor, the applicant of the contested trademark, could not be aware of its existence and of its use. The relationship between the parties, the General Court made it extremely clear that whenever two parties are bound by contractual or pre-contractual relationships, that necessarily implies a duty of loyalty in respect of one another. And that creates an assumption when one of the parties files as a EU trademark a mark that was already used by the other party to the contract, it creates the presumption of an awareness of the use of the earlier mark, and that also creates a strong indication that there was a breach of the duty of loyalty, which is implied by this contractual relationship. A specific example which was exemplified by the General Court concerned the case in which a trademark applicant filed a trademark which was identical to the trademark, to the non-registered trademark, which was given in license to him by another party. And the General Court found in this case that the reason for which the EU trademark applicant filed its trademark was just in order to avoid having to pay the royalties of the license agreement. And therefore, this breach of the contract and this willingness to create a confusion in the consumer's mind was accountable for bad faith in the TGR case. If we move on with the relationship between the parties, we find that the mark which is used by one of the parties to the contract needs not to be protected as such. We have an example of this in the case outsourced to India, where the sign outsourced to India, which was used as a domain name, is probably not trademark protectable to the extent that is descriptive. And as a result, it could be said that the use of such a sign outsourced to India could be free for the use of all, except in a situation where it can be shown that one of the two parties to the contract misappropriated this sign, protectable or not as a trademark, in order to register it or to obtain a protection together with figurative elements. And this would have the effect of preventing the other party to the contract from entering the European market. Another point which is relevant is that the duty of loyalty implied by contractual relationships does not last forever. It decreases in portion of the time that has lapsed between the stop or the cessation of the contractual relationship and the date of the filing of the trademark at issue. So the Court of Justice did not rule out the possibility that a filing which is made after a long period after the cessation of the contractual relationship could be made in bad faith, in particular where the filing of the EU trademark application had a commercial logic in the light of the applicant's activities. We will see this notion of commercial logic, which is not very clear in the court's case law, in a minute. Reputation of the sign which is used by another party. We have one example which was given by the General Court in the Simca case. Reputation of an earlier mark may not be as such enough to establish bad faith, but it can be an indicator, if this is supported by other factors, of the dishonest intention. On the facts of this Simca case, the mark Simca for cars was well known until the 90s in Europe, when the production of the car manufacturing stopped. However, 20 years and more later the cessation of the production of the cars, there was still a residual reputation attached to the name Simca, or what the General Court named a surviving reputation. And therefore, the General Court found that, or confirmed the finding made by the Boards of Appeal, that the application for the same mark in respect of identical products amounted to bad faith, because the intention of the trademark applicant was, again, to misappropriate this residual reputation, this surviving reputation, to the detriment of the legitimate owner, irrespective of the fact that this legitimate owner had stopped using the mark more than 20 years earlier. And the General Court emphasized that the surviving reputation of a historical mark was a well-known fact, and which sufficed in this case to establish the knowledge of the trademark applicant of the earlier mark. Again, the wider the use made by a third party of an earlier mark, the more likely it is that the contested mark has been filed in the applicant's knowledge of such a use. Knowledge may be assumed to exist on the basis of the duration of the use of the earlier mark. A trademark which has been used in Italy for many years could not be unknown to a professional of the same sector, in the construction works sector. And an important point which the General Court made is that the knowledge of such a use is not necessarily limited to a use made of an earlier mark in Europe. In Target Venture, the General Court emphasized that this knowledge could be established including on the basis of use of another trademark made by a third party outside Europe. Now, the core of the notion of bad faith is this dishonest intention, which, coming back to this Sky-Kick judgment, lies at least in two aspects. One is an anti-competitive misconduct in order to misappropriate rights belonging to a legitimate proprietor. And the second aspect is the misuse of the law or an abuse of the law without targeting one competitor specifically, but a misuse of the law which would be detrimental to all competitors collectively and to fair and distorted competition as a whole. So we will see a bit what are those the different facets of this dishonest intention, starting with the free ride or the willingness to take advantage of the reputation associated with a third party's right in Europe or outside Europe. We've seen the Simca example. Neymar was another example in which a trademark applicant filed as a trademark and for a number of goods the name of a famous football player. And the General Court found in this case that it could not be a matter of coincidence if the trademark applicant had filed the name of Neymar at a time when the reputation of the football player was rising, where he had already acquired some degree of exposure in the media and a certain status in the field of sports activities. And the General Court emphasized that what was relevant in this case and what surrounded and supported the finding of bad faith was that closely before the filing of the trademark Neymar, the same applicant had filed another mark which for the name of Iker Casillas, which is also a famous football player. And this surrounding circumstance supported the finding that, again, the strategy of filing trademarks corresponding to famous patronyms of football players was a strategy of bad faith aiming at monopolizing something which did not belong to this trademark applicant in order to benefit from the attractive force of the names at issue. Apart from free ride, we have this other aspect which overlaps also, but the focus is more on the blocking position which the trademark applicant acquires vis-à-vis a specific competitor. And I would like to explain a decision of the Boards of Appeal, which is currently pending before the General Court, and the hearing is in fact today, in the Shumisha case. Shumisha, the mark was applied for a number of foodstuff products, and this name corresponds to the patronym of a famous Moroccan chef, a woman who acquired a reputation in Morocco and to a lesser extent in France for cooking classes and TV programs relating to cooking. So in this case, the Conciliation Division dismissed the action because it considered that it was not established that the trademark applicant had knowledge of the existence of the chef Shumisha on the date when it applied for the trademark in 2008. And it considered the relevant point that the mark Shumisha had already been used by the trademark applicant in 2011 until 2015 being the date when the EU trademark was filed. This decision was annulled by the Board of Appeal, which found in substance that the trademark applicant was a wholesale trader in the field of foodstuff, and that he was a specialist of spices. He traded spices, and on that account, this professional of the foodstuff sector and of spices could not ignore the existence of the name Shumisha, which had acquired in Morocco, country which is well known for the spices, a reputation already back in 2008. And the Board of Appeal considered that the EUTM applicant had no other reason to apply for the trademark than to benefit from this reputation acquired in Morocco and to prevent Chef Shumisha from entering the European market for selling her own products in Europe. Now, the second facet of bad faith after misappropriation of third parties' rights acquired in or outside Europe is the abuse of the registration system. And one aspect of this abuse or this misuse of trademark law is the process of evergreening, which means extending artificially trademark protection and evading the requirement of use by making repetitive filings. The General Court did not rule out the possibility that repetitive filings could amount to bad faith if the intention of the trademark proprietor is not so much to use the different and separate filings, but rather to obtain an exemption from the obligation of use. However, in this Pelican case, the General Court had a very narrow interpretation or a very maybe strict requirement for establishing bad faith on account of repetitive filings, and it found in particular in this case, maybe not in others, but in this case, that there was a commercial logic for making those repetitive filings, one of the legitimate reasons being that the trademark applicant had an objective need to modernize his trademark and also to make repetitive filings in respect of different lists of goods and services. And in this case, the General Court held that a second or a third or a fourth repetitive filing in respect of a same mark or a slightly modernized version of the same mark could amount to a good faith application if the list of goods and services was narrower the fourth time than it was the first time. We have a similar finding which was made by the General Court in the Voodoo case. Another example in which, in this case, the Board of Appeal considered that there was bad faith on account of repetitive filings was the Monopoly case, which is also pending before the General Court. The Monopoly trademark was the subject of 3 different filings made over a period of less than 10 years in respect of similar goods or services, including in the later filings additional goods such as electronic toys or entertainment services. And so a cancellation action was filed against the third filing, and the Board of Appeal confirmed that this filing was made in bad faith on account of on account of a number of circumstances, but one was considered to be particularly relevant and decisive in this case, which is that the trademark applicant confessed and admitted explicitly that they had filed the trademark monopoly for the third time in order or as a strategy aiming at avoiding to have to submit proof of use in the context of opposition or cancellation proceedings. And in this case, the Board of Appeal made it clear that such a purpose, if it was the only purpose for which the trademark had been applied for, constituted bad faith because it amounted again to an abuse of the trademark registration system. You cannot apply for a trademark and you cannot repeat a filing just in order to be exempted from the obligation of use and from the obligation to submit proof of use in the context of oppositions or cancellation actions in which your trademark is relied on in support of your action. Now, the General Court will have to examine whether a number of factors are relevant when deciding whether the repetitive filing is made in bad faith. Those factors may be the relevance of the number of repeated applications. Logically, you would assume that 10 repetitive filings are more indicative of bad faith than just 2 or 3. The time lapsed between those filings might also be relevant. This is for the General Court to decide. But you can think in the abstract that filings which are made every 5 years in order to get an exemption from the obligation of use would be more indicated of bad faith than filings which are made every 2 years, for instance. And the General Court will also have to decide whether the actual use which is made by the trademark proprietor of some of the goods or services for which the repetitive filing or the repeat filing has been made would be a relevant factor. Of course, if no use has been made at all of the third, fourth, fifth trademark application, this is more indicative of bad faith than if a current use is made in respect of those goods and services. All this to say that, again, the overall examination of the case will lead to a conclusion which is specific to each concrete case, and this makes up for the difficulty to draw general patterns of what is bad faith and what is not. After the repetitive filings, we have another illustration of what is bad faith by means of an abuse of the trademark registration system. In the Luceo case, in which a trademark applicant had devised a very sophisticated trademark strategy, which was to take advantage of the laws of Austria and Germany, in which you can obtain a filing date without having to pay a fee for your application. So what the applicant did is that he regularly filed applications for trademarks in Germany and in Austria without paying fees. And if within the 6 months of the priority period, this applicant found that another applicant had filed a similar trademark as an EU trademark, then in such a case, the trademark applicant in Germany and Austria would file the same mark under the priority period or claiming priority in order to obtain an advantage vis-à-vis the EU trademark applicant and in order to monetize its agreement to such an application. Of course, in this case, the General Court confirmed that this amounted to bad faith because the applicant of the trademarks in Austria and Germany had no real intention to use his marks. His only intention was to obtain a financial compensation and to obtain a blocking position vis-à-vis a later EU TM applicant. This amounted to an abuse of law, having in mind again that this applicant had no intention to use any of the marks applied for in Germany and Austria and of the corresponding marks which were applied for in Europe, claiming the German or Austrian priority. We continue with a third illustration of the abuse of the registration system, which is the absence of any intention to use the mark. We are again talking about the same thing, but with different illustrations of the same concept. And in the Skykick case, maybe I should say something about the Skykick case, a preliminary ruling opposing the British company Sky, which is specialized in telephony, in TV broadcasting, and in the provision of broadband services on the one hand. And this operator had obtained registration for a number of marks consisting of Sky, in particular or including for software as a product. And this company entered into a conflict with another British company, Skykick, which used the mark Skykick for a very specific software and services in respect of a cloud migration. So on the paper, those two operators were not direct competitors in respect of each other. They were operating in adjacent fields, but they were not competitors. And as a defense, the defendant, Skykick, raised the issue or raised in a counterclaim of the bad faith of the Sky, the claimant, when filing the trademark Skykick in respect of software. And the defendant claimed in such a case that the mark Sky had been filed in bad faith because Sky had never intention to diversify its current activity, telephony, TV broadcasting, provision of broadband services, never had any intention to diversify this activity towards the field of software. So the Court of Justice said that there can be bad faith when there is no rationale for the application for registration of the contested mark, and no rationale meaning in light of the objective of the directive and the UTM, which is only to protect a trademark filed to the extent that the intention of the proprietor is to use this mark after some time. So if you manage to establish that the trademark applicant never had any intention to use the mark, then that may amount to bad faith. The Court of Justice, however, specified that bad faith cannot be presumed only on the basis of the length of the list of goods and services, and this was said already before by the General Court, and also by the fact that on the date of the filing, the trademark applicant was not engaged, was not involved in the field of activity which is concerned by the list of goods and services. So the fact that the trademark applicant had no economic activity corresponding or relating to the goods and services is not as such sufficient to establish bad faith. Reason is that when you apply for a trademark, there is always the possibility, you have the possibility to give this trademark in license, including where you are not operating in the field envisaged or concerned by the list of goods and services. So what is a bit frustrating in this SkyKick case is that the Court of Justice does not give more indications about how to establish the absence of any intention to use the mark. Something which was in the background of this case, which was not considered by the Court of Justice because it was not raised by the referring court, the British Court of Appeal, is the fact that Sky had, in fact, a number of trademark registrations corresponding to Sky, which had been repeatedly filed over time in order, again, to get an exemption from the use obligation. So again, the evergreening principle or the strategy to repeatedly renew filings in order to get an exemption from the use obligation could be indicative of an absence of any intention to use the mark. Another illustration of this lack of intention to use the mark is when a trademark applicant files a mark for the only purpose of securing a broader protection to another mark that this time the applicant uses. An example is Target Ventures, in which the company Target Partners operates a website which is called targetpartners.de, and this is the only website, targetpartners.de, which is active. However, this operator has also a number of other domain names, including targetventures.de, which is totally inactive, and the only purpose of this website is to mirror the content of targetpartners.de and to redirect the internet user to this targetpartners.de website. In this case, the trademark applicant filed a trademark application for targetventures.de just to, again, secure a broader protection for targetpartners.de in order to obtain what we may call a defensive mark. And another operator, which was using targetventures.de, filed a cancellation action based on bad faith and managed to establish that because the trademark applicant had no other purpose than securing a broader protection for target partners, then the registration of target ventures did not correspond or did not amount to a genuine and good faith intention to use this mark target ventures in the future. General Court said that the intention of obtaining, without even targeting a specific third party, which in this case would be the cancellation applicant, but the intention of obtaining an exclusive right for a purpose other than using the mark in the future may be sufficient to establish bad faith. If we move on to the notion of commercial logic, which we have already addressed in the course of this presentation, we find that there are few examples in the case law, and the case law is rather a bit uncertain as to the limits or extents and limits of this notion of commercial logic. What we find is an analogy which can be drawn between good faith on account of a commercial logic for the application of a trademark and good faith in the context of Article 8.5. In this case, Bulldog against Red Bull. That was a preliminary ruling case in the Netherlands, if I remember well. Red Bull had acquired reputation in the member state in respect of energetic drinks and had filed an infringement action against Bulldog, which was operating a chain of hotels and restaurants and which had over time diversified its activities towards bar services, including sales of beverages. So at the time when Bulldog had filed their trademarks, or had filed their trademarks, yes, Red Bull had already acquired a reputation. However, the Court of Justice said that the referring court should examine whether the registration of Bulldog was made in good faith to the extent that use of this sign had commenced, had started at a date which was earlier than the date of acquisition of Red Bull's reputation. The conclusion of the Court of Justice is that there can be good faith if you try to consolidate a competitive position already established, or if your trademark registration corresponds to a natural extension of a business that you had started before. And in this case, the General Court did not rule out, this is for the referring court to assess, but it did not rule out that there was a justification for applying for the mark Bulldog in respect of beverages on account of the fact that the applicant had diversified its business activities from hotel and restaurant services towards bar services and beverages. Another illustration of this principle can be found in the context of bad faith in the Cipriani case, in which the General Court found again a commercial logic in extending trademark protection from the field of hotel services, Cipriani is a famous hotel in Venice, towards the fields of beverages and foodstuff. A couple of minutes on the scope of the annulment, and this will conclude my presentation before the question and answers session. The scope of the annulment on account of bad faith is still relatively uncertain. The Court of Justice said, as a matter of principle in Skykick, that if bad faith is established in respect of some goods and services in particular, then the scope of the annulment should not go beyond those goods and services. It is sufficient to note that if it follows clearly that where the ground for invalidity exists in respect of only some of the goods or services for which the mark has been registered, then the trademark is to be declared invalid only in respect those goods and services. This was not clear because a judgment of the General Court in the Salini case had considered that bad faith was a defect which justified the annulment of the trademark as a whole, having in mind or giving predominance in the conclusion to the intention of the user, of the trademark applicant, intention which vitiated the application as a whole and as such. And this defect therefore necessarily extended to the entirety of the goods and services. Court of Justice nuanced or corrects this finding by saying, no, you must have an examination of the ground for bad faith in respect of each category of goods and services. In another judgment, Stilo and Cotton, which is which brings uncertainty, the Court of Justice says, yes, well, what you have to see is that it is not impossible that bad faith would extend to the entirety of the list of goods and services. In such a case, the General Court had annulled the contested mark only in respect of goods and services which were found to be similar to the earlier mark. And the Court of Justice annulled this decision of the General Court on account of the error that it had made to limit bad faith in situations in which goods and services were similar. And regarding the extent, the extent of the annulment of the contested mark, the General Court says that you need to take into consideration the fact that the application for invalidity was filed against the contested mark in its entirety, and that you need to examine the intention of the trademark proprietor for all the categories of goods and services, including those which were found to be not similar. The Court of Justice concluded by saying that the General Court did not examine whether the application for the mark had a commercial logic in the light of the trademark applicant's activities. So what is difficult in reconciling Skykick and Cotton is to determine whether the Court of Justice allowed the annulment of the trademark as a whole in a situation in which the mark was filed in the context of a misappropriation of an earlier right, corresponding to one of the two scenarios we have seen in the course of this presentation. So the uncertainty, to make it clearer, the uncertainty is whether the Court of Justice intended to say that when you have an abuse of the law, as in Skykick, then the scope of the annulment might be limited only to those goods and services concerned by the abuse itself. And whereas in the context of misappropriation of a third party's rights, as in Cotton, then the bad faith would vitiate the entirety of the trademark, including for the entirety of the list of goods and services, first alternative, or whether the Court of Justice only meant that you can obtain an annulment for the entirety of the contested mark, provided you establish a bad faith in respect of each of the categories of the mark, each of the categories of the goods and services listed in this mark. This is still relatively uncertain, and the only thing I could give you is a personal opinion, but I will refrain at this stage. This is time to conclude my presentation and to address a number of questions from the audience, if we have any. Time to check. We have a question from Zagreb. Why is bad faith not a basis for opposition, but can be used only in invalidity proceedings? Many national jurisdictions, including the EU directive, don't allow to register a mark if applied in bad faith. It is true that there is a provision, Article 8.3 of our trademark regulation, a mark which has been filed by an agent, this is a provision that can be raised in the course of opposition proceedings, whereas bad faith can only be raised in cancellation proceedings, invalidity proceedings. The reason for it is probably that bad faith necessarily implies an extensive examination of facts, and the EU legislator considered it more appropriate to make this extensive examination of facts in the context of invalidity proceedings, whereas opposition proceedings should be or should only concern grounds which are more straightforward and which can be examined without such an examination, extensive examination. Second question. From Bucharest, the claimant in an action for cancellation for bad faith has access to a set of objective facts that she may prove are knowledge of the prior use of the sign and a dishonest intent at the time of the application, separate and cumulative requirements that have to be proven. Our knowledge of the prior use of the mark and a dishonest intention, separate and cumulative requirements. They are certainly cumulative. Separate, it is hard to say, again, whether you need to show things separately. The case law, including in the case of misuse or abuse of the law, does not even require knowledge of the use of a third party's mark. We've seen an example in the Luceo case where the trademark applicant in Germany and Austria and who filed under priority similar marks in order to block access to third parties was certainly not aware of the use made by the signs by third parties, but that did not bar the application of bad faith. What you need to show as a whole is a dishonest intention, and that the knowledge of prior use made by third parties would be one of the factors indicative of such a dishonest intention. But you do not need to prove those two things, knowledge and dishonest intention, separately. Next question. Actions for cancellation for bad faith imply huge losses of time, money, and energy. Should bad faith be examined ex officio by the competent authorities? The answer is clearly no, for the reason that how can we, as an administration, examine facts on our own? This is at least something which is clearly enshrined in our trademark regulation, EU trademark regulation, that the parties have to submit the facts, in particular when there is a clear intention or to misappropriate third parties' rights. So this is not something that we can examine ex officio. Our examination would only be partial, and that would not satisfy the needs of the users. Next question. From Warsaw, is licensing of the trademark to a company prior and subsequent to the filing of the trademark application considered as intention to use the mark by the author proprietor of the trademark? So the question, and I'm sorry, is unclear in the sense that, of course, if the trademark applicant, the one who applied for the contested mark, had already started using the mark and had given it to license to third parties, yes, that may be indicated of good faith because he started using the mark before registering it, so there was certainly commercial logic. Now, the issue is different, and that would correspond to the TGR case, which is a Polish case, and that's why I'm wondering whether this question would be relating to this. In the TGR case, the trademark applicant was not the licensor, but the licensee, and therefore the licensee tried to circumvent the obligation to pay royalties relating to the license by applying in its own name for the trademark. That could be then, of course, a situation of bad faith. Alicante could be a common location, the same office building, a valid reason for a cancellation request based on bad faith. Common location, same office building, a valid reason for a cancellation. I don't know what is the background of the question. If my neighbor applies for a mark which he knows or of which he is aware because we are neighbors and he knows I'm using it, or because he knows that I have the project of using it, yes, that can be an indication of bad faith. But this might not be enough, and the reason for being, or the fact of being in the same building is probably a relevant factor, but not sufficient as such to establish bad faith. And this is it. This will conclude my presentation. Thanks a lot for your attentiveness. I'm perfectly aware that this was a rather technical topic and that there is a lot more text in my slides than necessary. I hope, however, that these slides will be documents in support of your future research and practice in this field. Thanks a lot, and hope to see you another day.